Testing 1 2. Testing 1 2. Testing 1 2. Testing 1 2. 1 2.
Testing.
Okay, we'll give it just a couple minutes before we get started. Is anybody from the Attorney General's office here? We invited the Attorney General. We'll wait just a little bit and see if he can make it. Pro Tem Treat's not going to be able to make it today. His son is in the hospital. I think he might have released a statement already, but our prayers are with him. He's with his son today.
This is a first for me in the Contingency Review Board.
Yeah, me too.
1 in 8 years.
Yeah.
First today.
What time is it right now?
3:35.
3:35.
36.
Counsel, have you talked to the Attorney General? Was he coming? Okay. Rick, you can get started here tonight. Okay. All right, well, welcome everyone to the August 28th, 2024 meeting of the Contingency Review Board. I'll now call the meeting to order. Ms. Hicks, please call the roll.
Yes, sir. Speaker of the House, Charles McCall.
Here.
Senate President Pro Tempore Gray Treat. Governor J. Kevin Stitt.
Here.
And OMS Director Rick Rose.
Present.
Thank you.
Okay, thank you. Do we have a quorum?
Yes, sir.
All right, thank you. Ms. Hicks, can you confirm that we've complied with the Open Meetings Act?
Yes, sir.
Excellent, thank you. Okay, well, good afternoon, everybody. Thanks for being here. We are here today to make sure that the board complies with 51 Oklahoma Statute Section 200 as the Attorney General and the Plaintiffs' Counsel have asked a federal judge to sign a consent decree binding the Commissioner of Mental Health in the Briggs versus Friesen case. And so I want to be clear, today's meeting may end up being for the sole purposes of gathering information, given the court is still considering whether to approve the consent decree that the Attorney General and the Plaintiffs' Counsel have agreed on. So the Speaker, myself, and the Pro Tem would definitely be here if it wasn't for his son's accident, are all accountable to the taxpayers. And before any agreement of this magnitude is finalized, we need to ensure that this is a good deal for all 4 million Oklahomans. And the only venue available since there's only 3 people on this Contingency Review Board for us to get together is in this setting. So I cannot discuss this with the Speaker or the Pro Tem unless we're in this open meetings format. So this is the only venue that we have for any 2 of us to have a conversation about the consent decree or the lawsuit in general is in this open meeting act, is open meeting like this before, because 2 of us makes a quorum. I've invited the Attorney General, Gettner Drummond, and the Mental Health Commissioner, Ali Friesen, here today so that the board can learn more about the case and how this agreement was reached. Commissioner Friesen has worked tirelessly to improve mental health outcomes, and I am so proud of the progress we've seen at that agency and for the individuals impacted across the state. The last thing I'd want to see is any interruption to that progress due to a fundamental misunderstanding of the care mental health provides. This really isn't a zero-sum game. We can and we must care for those in our justice system who are struggling with mental health conditions and also protect Oklahoma taxpayers. And hopefully this meeting can give us a path forward. Before we invite our guests to join us for this discussion, I'd like to share that while I know Commissioner Friesen and General Drummond, well, General Drummond's not here, but I want to honor everybody's time. So we're going to keep this meeting really efficient. We've got a couple questions we wanted to ask. So if it's possible, we're going to stick pretty close to our agenda here, and we'll move on to agenda item. We're going to skip agenda item number 5. And I don't need to do anything to skip that, right? There was no action if General Drummond's not here. Okay. So Commissioner Friesen, can you please join us up here? Yeah, thank you. Thanks for joining us. You know, you've been doing some incredible work, and I know you're improving mental health outcomes for all Oklahomans. Thank you for your efforts. We're obviously here today to discuss the consent decree. and you've had at least some involvement, some conversations about it, and it will be helpful for us to better understand, whether this consent decree, we're really trying to get to the matter, is this good for the state of Oklahoma taxpayers? Is it good for mental health? Is it good for providing services to those that are in need of mental health services in the state of Oklahoma? And I know that myself and the speaker, and then Director Rose have a few questions. So we'll just jump right in. So my first question, did you tell the Attorney General that you did not approve of the consent decree?
Yes, sir. Across multiple occasions, in person, over the phone, and documented across several emails. I made it very clear that there were two non-negotiables for me. And I made it very clear time and time again that I cannot and will not agree to the consent decree as it is drafted.
Okay, thank you. When did you most recently say that? Did you say it in writing? When did you let him know that you didn't agree with it in the most recent time?
Yes, it was a combination of phone calls and email. The most recent email was sent on August 14th, the night before the most recent hearing. And then again, there was an email on August 23rd that was sent reaffirming my stance and that my concerns had still not been addressed. And those were consistent with my two non-negotiables that I communicated directly with General Drummond and his staff approximately 6 months ago.
Commissioner, do you know if the Attorney General shared that with the court?
It's my understanding upon reviewing the transcript of the most recent hearing that those concerns were not communicated.
And is that something you would have expected your attorney to do?
Yes.
So can you tell me, why don't you approve of the decree?
Great question. So firstly, I think it's relevant and necessary to share that I'm a clinician first and foremost, didn't even want to be in leadership to begin with. And I found myself observing opportunity to improve systematic changes to actually impact the system, both in the private sector, and now I have the honor of doing so in the public sector. So God has placed a responsibility on my shoulders to truly be the voice for those that cannot have a voice for themselves. And I will always stay true to that. And that is why I took the honor of having this job. So I took the challenges specifically of this job to transform the system. And today's topic represents a piece of that system. But again, it is one component of that system. And it would be outside of my ethical, legal, and moral standing and statutory requirement to agree to the contents of the consent decree as it exists today. So the decree is written today in a way that removes my ability to provide services to those that are in need in a jail-based setting. This is inhumane and goes directly against, again, my ethical and moral standing, not only as a clinician and as a leader, but as a human being. I cannot and will not agree to withholding services from those that are suffering.
So just to clear it up, this is not in the best interest of the state of Oklahoma.
That is absolutely correct.
And you believe that this consent decree would affect your ability to carry out your statutory duties as the commissioner?
Correct. As it is written today, that is absolutely accurate.
Okay.
So, and I'm happy to go into more specifics.
Yeah, I'd like to know, do you think that this effectively, if the consent decree was agreed upon, that it would effectively rewrite Oklahoma law and your ability to provide services inside the jail? Is that what you're saying?
Yes, and there's multiple factors. That is certainly one. So it's not in the best interest of the state for multiple reasons. If you examine the terms carefully, it removes the ability for the clinicians and the expert from our state to drive evidence-based care across specific populations and instead places clinical decisions in the hands ultimately of attorneys. If the state enters into the decree as written today, it positions the department for immediate violation of court orders to provide competency restoration services to those in need and puts the state on a conveyor belt of endless fines and contempt citations that will result in additional financial burdens. We're talking $500 per day per citation. And that includes potential criminal prosecution of not only the department, but criminal prosecution even of me in the role of commissioner. So there are multiple violations as it exists today. And remember, what I've asked for to this point with General Drummond is the allowance for more time. Because remember, I've been in this role officially since the end of February. And we have not had time to identify the root causes of the problem and apply targeted evidence-based solutions to address the alleged concerns. So the decree would force us to simply apply a blanket approach to all potential solutions that could solve these problems, which means that we lose sight even from an experimental methodology standpoint to see what's actually going to work. If you apply all potential solutions to a problem, you're not going to know what fixed it. So not only are we taking away our opportunity to sustainably solve the problem, but they are removing my statutory authority to, through Oklahoma state law, through my position as commissioner, to authorize when individuals should be transferred to the Oklahoma Forensic Center. So the way that it is written today is removing that authority. And what that means is the attorneys, not the clinicians, are saying this is what best practice looks like for an individual that needs competency restoration treatment. And that means that's one option, which is a bed, because beds equal dollar signs. In the original decree as it was drafted, the requirement was for us to build 200 additional beds. The legislature generously appropriated us funds to build 84 additional forensic beds in Veneta, which are under construction and set to open in June of 2025. So it is certainly not in the best interest of the state to move forward with allowing attorneys to make clinical decisions when we know that a bed is certainly appropriate for the high acuity individuals that are dangerous and that need that level of care. However, we have restored 216 lives back to competency since January of 2023 through jail-based competency restoration programs. So our ask, and it's in accordance with the evidence, is to maintain that triage front door, just like you would in an emergency room. Not everybody needs to go to the ICU. If you go into the emergency room, there's multiple points of access that you could go to. So this is taking away our ability and our clinicians' ability to dictate what level of care is appropriate in line with the acuity of their clinical presentation.
So thank you for that. That was really good. In order to implement this consent decree, would there be other cuts to other programs? How would it affect your ability to provide services outside of just what we're talking about here on people that are currently incarcerated waiting on trial?
Right, absolutely. That's a wonderful question. So not only does this remove our ability to provide those jail-based competency restoration services, and this is an important point, in 75 out of the 77 counties. In the decree, it is drafted that a pilot program is to be launched in the Tulsa County Jail that will allow for jail-based competency restoration services in the defined format that the consultants see appropriate. In the consent decree, it also drafts additional language to include one unidentified additional county. So that means 2 counties out of Oklahoma would be allowed to have access to jail-based competency restoration. So in my calculations, that leaves 75 counties without access to that highly needed level of care. So not only are we removing that, but if we have to take unnecessary appropriated dollars and put them towards this consent decree, we are also threatening enormous access points across our care continuum that not only provide life-saving care for Oklahomans today, but also will disincentivize us to build out our continuum that would prevent individuals from even entering the criminal justice in the first place. So we're truly building and adding to the bottleneck that we're already working against.
Thank you. So getting to the money part of it, how much would it cost the department if we implemented, if this plan was signed off on and agreed to? What would this cost the taxpayers, or what would this consent decree require you to pay?
So as it's written today, a conservative estimate would place a burden of approximately $96 million over 5 years. So there are a lot of variables that go into that cost. The estimate of $96 million does not include the likely requirement from the consultant panel and the plaintiffs. The plaintiffs have remained a decision maker over the clinical decisions in conjunction with the consultants. So this will likely not remove or not include the additional request or demand, rather, to add additional forensic beds. And again, we're already adding 84 additional beds in Veneta. So this could cost a minimum an additional $125 million, not including staffing or operational costs for this said facility. This also excludes multiple items that are left to the discretion of the consultants, including staffing, data requirements. There are multiple items that have question marks next to them because it is in the hands of the consultants. It makes it very hard for the state to sign off an agreement, not being able to identify what are one-time costs and what are annual recurring costs to the department.
So 96 million in 5 years, where does that money come from?
This money would have to be added to additional funding through appropriations from the legislature. We're dedicated to being good stewards of taxpayer dollars, and I've already made that very clear in eliminating $3.25 million in unnecessary contracts in my 6 months at the department. We are ensuring that the funds are going directly to the identified needs of Oklahomans, because remember, that's why I took the job. So this decree would remove our ability to effectively allocate funds to all of those identified behavioral health needs across the state. And this is very important. In its most extensive form, meaning if the consultants have their way and get to pick whatever options they see appropriate, in its most extensive form, the financial requirements from the decree could encumber approximately $142 million. Otherwise stated, around 37% in the first year of the department's total annual state appropriated dollars, with the continued impact of tens of millions of dollars. 37% of our annual department appropriated dollars would break our organization and would rid us of necessary and critical crisis access points for children, for adults, for geriatric population across our entire state.
Governor, I ask a
Please.
question. Commissioner, I have been in the legislature now for 12 years. When I entered into this building, the state of Oklahoma, through the Department of Human Services, was under an agreement called the Pinnacle Plan. 12 years later, it was here before I entered the building. It's still in existence today. Along the way, legislatures has made additional appropriations to DHS on this effort to satisfy the plan. But yet, the legislature's told every year, you're really close, you're getting closer, you're a little close. We're still not released from that plan. Is this decree, in your opinion, is it a Pinnacle Plan 2.0 for mental health that we've seen in the Department of Human Services?
Sadly, it's very, very similar to the Pinnacle Plan in ways eerie as much to say it has the same group of plaintiffs' attorneys, the same that were involved in that original agreement with DHS. It is also the similar structure with the consultants having the say in conjunction with the plaintiffs' counsel. It also has a similar impossibility of exiting the agreement in a reasonable time frame. And that has been one of the biggest catching points, is will we ever get to a point where we can satisfy, in their definition of the consultants, a reasonable compliance? And that is a subjective term and makes me horrifically uncomfortable.
It seems the experience with the Pinnacle Plan from a legislative standpoint is we've made the additional appropriations year after year, yet the goalposts seem to get moved in that plan. Do you see this, in your opinion, or when you look over this decree, is that what would likely happen with agreeing to this decree?
I can't predict the future, but what I can say from learning about the Pinnacle Plan and from learning from our wonderful attorneys and criminal justice teams and the research that happened before my entrance beginning of this year, there are several states that are in similar agreements and are facing challenges exiting or meeting those requirements of substantial compliance. Again, because the agreements tend to lack the verbiage to support an objective definition of what substantial compliance looks like, and to your point, continues to move the goalposts.
Thank you.
Thank you for that, Speaker. And would it surprise you to learn, I did a little research on the Pinnacle Plan, that DHS has spent over $400 million on the Pinnacle Plan to date, $18 million on consultants, So that certainly, Speaker, I'm glad you brought up that comparison. That definitely concerns me. So do you want this board to approve this consent decree?
At this point, as it's written today, I would advise the board against approval.
Okay. You know, what are your thoughts on the statement made by the Attorney General to the court? So in the court, the transcript, he said that the state's competency restoration system is chronically and seriously broken, and that the plaintiffs were very likely to succeed on their due process claims.
So the jail-based competency restoration program was launched in January of 2023 under previous administration. I cannot speak to the processes or expectations that were put in place at that time, but what I can say is moving forward, the bar has clearly been set at excellence and truly nothing less. So with that said, the department has to be afforded the opportunity to implement improvement plans, to evaluate what's happening across the system. We are a very, very large organization. So we have to have the freedom to assess, evaluate, and implement our improvement plans outside of the burden of a consent decree that is going to eliminate our ability to apply evidence-based practice. So since January of 2023, there have been 216 lives that have been restored to competency, which is a game changer for these individuals and the trajectory of their lives moving forward.
So do you have any concerns? Right now, the Attorney General is your counsel. Do you have any concerns if the Attorney General continue to represent you going forward?
Well, if you read the press release from his office this morning, would you feel comfortable with this individual representing you?
I didn't see the press release yet.
You can read it. Abigail, I'm sure, has it.
Okay, so that's a no?
I believe the Attorney General has represented us as he sees fit. However, like I've said, the consent decree as it's written today violates my ethical and legal responsibilities as commissioner.
Commissioner, do you feel like the representation you're receiving from the Attorney General in his office represents or reflects what you as the client want to transpire in the case?
So I stated this before, I'll always seek to be a voice for those that cannot have one for themselves. Therefore, I will always prioritize what is in the best interest of Oklahomans and those that we serve. Our representation moving forward will need to be clear and aligned as to this being the priority of the department. And throughout the last 6 months, the definition of what is in the best interest of those we serve between parties has not been in alignment, and I do not see that changing.
So you've kind of walked through what all the department's done, and I know you haven't been there a super long time. Do you believe that a consent decree, this is necessary for you to resolve the issues that are brought up, and we all want to make sure that we have this competency and we get people well as quickly as possible? Can you do this without the consent decree?
Absolutely. In the last few months, we were given the green light from the Attorney General's office to start implementing improvement work plans. And since that time, our lead over criminal justice has made enormous gains across multiple domains, including not only the addition of our beds and making sure that construction is on time and on track, but we're looking at provider requirements, we're looking at communications, we're looking at a certification program, contract compliance processes, our infrastructure, how do we have more of a real-time pulse as to where people are in the process, looking on county-specific work, since each county has different representation of different levels of needs. And we have an enormous win in onboarding our new chief medical officer as of Monday of this week, Dr. Jason Beeman, who happens to be a board certified forensic psychiatrist and a regional expert in all things competency restoration and criminal justice. He volunteered to join our efforts a few weeks ago and said, if I'm going to complain about the department, I want to be a part of the solution. And I immensely respect that. So it should be enlightening for those that do have criticism of the department to realize that one of the most vocal critics of the department has now come and wants to be our chief medical officer because he has seen firsthand what we are working towards and the improvements that we are implementing. So there are multiple things in conjunction with his arrival. We'll be launching the Project Echo around the forensic education, ensuring our forensic examiners and those that are treating those back to competency have access to the highest level of training possible, and they're held accountable through the department to attend those continuing education modules so that we can ensure that the content is there. So with these improvements, our new leadership team, myself, Dr. Beeman, we need to be given the chance to show these improvements and show up to the table with the data, not the feelings, not the politics, but with the data around what we're improving and doing for Oklahomans. This consent decree not only is an overburden to taxpayer dollars, but also interferes with our ability to do what is right and to make those changes.
Wonderful. Are you open to a fair, reasonable settlement? And what does that settlement, what would be some essentials that you would think would need to be in a fair settlement?
Yeah, absolutely. And that has been what we have been working toward over the last 6 months. And to my initial points, the non-negotiables that were outlined from the beginning have not shifted. And that's why I'm here today, because I felt I have no other option. So in order for us to consider a reasonable settlement, it would have to be in alignment with state and federal law, create no additional burden to the taxpayers, serve the best interest of those that we serve, and the plaintiff's counsel must be removed from the decision-making process.
Excellent. So I know you want to provide the best possible care for the criminal defendants who are temporarily incompetent to stand trial. The Department of Mental Health provides services for millions of others as well.
Mm-hmm.
Do you know on a percentage basis, what percentage of the individuals you serve are represented by the criminal defendants at issue in this consent decree of the total that you guys are providing service to?
So as of this week, when we look at the group that is outlined in the decree over our overarching population served, it represents 0.1% of the overall population that our department serves.
So this consent decree, you've said it's going to be almost $100 million over just 5 years.
Correct.
If it continues to the speaker's point, like the Pinnacle plan, it could be double that easily. We know they've spent $400 million, but we know in 5 years, if we were able to get out of it in 5 years, if this was accepted by the state, it costs $100 million for 0.1% of the population. That's what you're stating?
That is correct.
Is there anything else that you'd like to share with us before we wrap up today? And if the judge is inclined to enter into this consent decree, would you be open if we shared our thoughts with the judge?
Absolutely. I would be more than happy to present in front of the judge and discuss some of the similar concerns that we've discussed here today. I think there are a few things I'd like to make sure to mention. The odd, paradoxical nature of this entire situation is, frankly, I feel like I have been the attorney and the plaintiff's counsel is getting to play clinician. And I didn't take this job to be an attorney, although I might have to go to law school now. But I took the job to transform the system, right? So the paradoxical nature is that we are being accused of violating constitutional rights. And the consent decree as it is written today is removing our ability to provide, as we are required per statute, timely competency restoration treatment. They are removing our ability to do that through taking away jail-based competency restoration treatment across 75 counties. If we have the ability to provide an individual with timely treatment, and we do not, would we not call that a constitutional rights violation? I have enormous, truly excitement and optimism for our new team. We finished our strategic plan. We are ready to hit the ground running. And I am enormously optimistic of the change we can drive, not only in this space, but across the entire state in the care continuum to prevent those from entering the criminal justice system that don't have to be there. The evidence is strong. And what we are asking for is a chance to execute on those improvement plans, to be represented adequately, and to give Oklahomans a shot. I don't want our legacy of our administration to be we were stuck on an endless conveyor belt of lawsuits and of fines. I want us to be known for driving change and for saving lives.
That's good.
Very well said. Are there any other questions or comments before we let Commissioner Friesen?
Governor, I don't have any more questions for the commissioner, but I do, I'm not sure where it would fit in the agenda or where you'd like it to be. I would take it up, but I would have some comments for the record.
Okay, all right, perfect. Well, thank you so much, Commissioner, for being here and answering our questions and providing some light on this, and very, very helpful. Thank you. Thank you very
gentlemen.
much. Well, let's move to agenda item number 7. So given that the judge has not decided on whether to approve this consent decree yet, I think it makes the most sense for us not yet to vote to approve or disapprove this decree. And the Attorney General even had sent an email to our office that said it would be premature to take any action at this time. So I agree with that.
Attorney General, is he declining to appear today or?
Well, yeah, I think so. Yeah.
Okay.
I think he's not here, but he sent an email to my general counsel and just said it was premature to decide on this consent decree. So I think I'll make a motion that we just table agenda item number 7, not take any action on it. I don't know, do we need to vote on that?
I'll second the motion.
Yes, sir.
Okay, you'll second that?
I will.
Thank you. Will you please take the